The next question in Unit 1 is origin and development of international law. So, origin. So, many countries and religions have given their own source of international law. Originated, they have contributed for international law. We will see one by one. The first are Jews. So, what Jews did were they developed relation among different states, and which were regulated and governed by certain rules, and they strictly followed it. So they established a relation between other states, and they made certain rules and regulations to govern this relation, and the Jews strictly followed it. The next were Greeks. So what Greeks did were they defined the definite rules for relation between states, and they defined the war rules, how to do war they defined, and they used to do pre-declared wars. If they want to do a war on country, they used to pre-declare it, and they used to solve the dispute by arbitration. If there was a dispute among states, then they used to solve by arbitration. And prisoner exchange for ransom was also there during Greeks. Romans. So what Romans did was that they defined the rules for just wars and unjust wars. They classified wars as just wars and unjust wars, and they defined rules what are just wars and what are unjust wars. And they also gave rules on how to end wars. The next are Hindus. So in Ramayana, there are rules for relation among states, and in Bhagavad Gita, just and unjust wars are defined. And war declaration, they used to do war by pre-declaring it. The next are Muslims. So Muslim rulers in India used to make treaties among different states, and Muslims also defined war rules, and they says that non-combatants should not be attacked during war, and women and children should be protected during war. This is the origin. The next is development. So there are three stages in development. 16th and 17th century is the first stage, 18th century is the second stage, and 19th and 20th century is the third stage. In the first stage, 16th and 17th century, there was a centralized government called feudalism and church in the European states. So in the European state, they had a centralized government, and it was divided into feudalism and church. In the Treaty of Westphalia 1648, it ended the religion rule. So this Treaty of Westphalia 1648, this ended the rule of church and feudalism. So after this, states started to building relation among each other. So religion rule was ended, they were free, and they started to establish relation among states. And during this period, Grotius, the father of modern of law nations, was born. So Grotius is the father of a modern of law of nations, model of nations, and he was born. And he defined the law of sea, and his famous work is the De Jure Belli Ac Pacis, which gives on the law of war and peace, which talks about the law of war and peace. And he says that natural law is the basis of international law. The next, in 18th century, schools were defined. All the schools came into existence in 18th century. We have natural law school, we have positivist school, auto limitation theory, etc. They came in 18th century. And in 19th and 20th century, we had a lot of development. Like for example, Congress of Vienna 1815. They defined international rivals for the first time. And then we have Declaration of Paris 1856. They defined rules for unarmed civilians not to be harmed during war. And then we have Geneva Convention 1866. In that, wounded and sick of war should not be attacked. Rules were made. And then we have Hague Conferences of 1899 and 1907. So they made several conventions. And the United Nations was established in October 24, 1945. During this period, the next concept in Unit 1 is theories of relation between international law and municipal law. This is a very important question, and it has been asked repeatedly. So what are the theories governing the relation between international law and municipal law? We have total 5 theories in total. The one is monism, the next is dualism, the third is specific adoption theory, then we have transformation theory, and then we have delegation theory. So monism. What is monism? Monism is the scientific analysis of internal structure of law. So what their view is that international law and municipal law are connected each other, and they are branches of unified knowledge applicable to human community, and man is root to all laws. So what monism says that international law and municipal law are one and the same, and they are both are true laws, and they are connected to each other. There is no difference between them. So criticism. In practical, international law and municipal law are two separate systems of law, And states are sovereign, not bound by international law. So states are sovereign in their own way and they are not bound by international law. They are only bound by municipal law or the criticism of monism. The next is dualism, the next theory. So according to dualism, international law and municipal law are two separate laws. They are not connected. So reasons, the jurist called Tripel give reasons. What he says is that in subject, municipal law is individual, but in international law, subjects are state. Origin. So in municipal law, origin is will of state, but in the international law, origin is common will of states. So that's why in the municipal law and international law are different. The dualism theorists say. Criticism. What are the criticism for dualism theory? So international law is not just binding on states. So international law is not just binding on states, it is binding on individuals and international organizations also. The next criticism is that state will is the common will of people. The state will, what they say is nothing but the common will of people. And state has to follow some rules without its will. So even states have to follow certain rules without its will. The next is specific adoption theory. In this theory, they said that international law is not directly applied to state. So what they say is that when international law is created, it is not directly adopted to states. So states should either permit it or specifically adopt it by the way of treaties. So only if states permit it and accept it, only then it is applied to states. This is specific adoption theory. Criticism for this. So some principles of international law are applied on state without specific adoption. So even if the state does not give permission, there are certain rules which are applied on them. For example, customary rules, they will have to obey them. The next is transformation theory. So what transformation theory says is that international law, if it is when created, it is not directly applied to states. It undergoes a transformation to apply to state. It will have to go under a certain transformation if it wants to be applied to municipal law or state, or else it is not applied. Criticism. So we have some law-making treaties which are applied without a transformation. The next is delegation theory. In delegation theory, it states that it is a evolved way of transformation theory. So this is a transformation theory. When it failed, they brought the delegation theory. So what delegation theory says is that it is the constitution of each state specifies on a procedure of undergoing international treaties. So constitution of each state, every state, even India, has a way to deal with treaties. We have defined rules on how to deal with other states, how to make treaties with other states. So this is a delegation theory. Criticism. Each state is sovereign and does not consider anyone above. So even if the states have made rules on how to deal with treaties, if it comes to sovereignty, they will obey their own laws. They will not obey any other laws. The next concept in Unit 1 is subjects of international laws. So who are the subjects of international laws? We have 3 theories in total. The first theory says that states alone are subjects of international law. The next theory is that individuals alone are subjects of international law. And then we have third theory, which states that states, individuals, and certain non-state entities are subjects of international law. So we will see one by one. The first is states alone are subjects of international law. So what it says? International law regulates conduct of states, and only states are subjects of international law. They say. And Percy Corbett says that individual only objects and states are subjects. So according to them, individuals are only objects of international law. Only state is the subject of international law. So emphasis separateness of sovereignty of states and not on basic principles. Criticism. What are the criticism to this theory? It fails to explain case of slaves and pirates. So we have slaves and pirates and they are individuals. So this theory fails to explain the case of slaves and pirates. International law imposes rights to slaves and obligation on pirates on all states. So if there are slaves, then the international law gives rights to slaves. And if there are pirates, then it is obligation of state to punish them. Then editors of Oppenheim book says that the state is not only subject, there are other subjects also. Then Schwarzenberger said individuals are basis of society. The case for this is reparation for injuries suffered in the service of the UN. So in this case, ICJ, International Court of Justice, held that if an UN member, if an United Nations member suffers injury, then UN can bring claim on state and state is not the only subject matter. In this case, it was held. The next subject is only individuals are subjects of international law. So Kelsen is the main here. He says that Rights and duties of states and of men who compose them. So the rights and duties of states are nothing but the rights and duties of men who compose them, he says. Then rule of law is applicable only to persons. The international law duties are duties of individuals, and international law and state law are same, he says. Then state law applies immediately, international law applies immediately, he says. Criticism. So, according to his view, only individuals are state subjects, and no states are not state subjects, he says. Criticism. What are the criticism to his theory? So, primary subjects are states. So, even though he says that individuals are the only subjects, the primary subject in an international law are always states. And according to ICJ, only states can be member of proceedings if there are court proceedings, and according to International Court of Justice, only states can be member of those proceedings. And in the Polish-German Convention of 1922, individuals can dispute against states. So individuals can dispute against their own state. So state is the subject here. And in 1965 Convention on Settlement of Investment Disputes between states and nationals of other states, state can enter into dispute. So in this 1965 treaty, it was decided that the states can enter into dispute. So states are also subject matter. The next thing is states, individuals, and certain non-entities are subjects. So several treaties conferred upon individuals, 1965 conventions. So conventions are defined here. So dancing railway official case. In this case, Poland was acquired and it doesn't give right to railway officials, individuals. So not a party. Court held to enforce right. So what happened was Poland was acquired by a different state, and Poland had a railway company, and they refused to give right to this railway officials by saying that individuals are not a subject, only state is a subject of international law. So court held that no, you have to give right to individuals also. The next is 1945 Geneva Convention on Prisoner of War. Rights were given to prisoners. And then we have Nuremberg and Tokyo tribunals. Obligation on individuals. Then we have the Genocide Convention of 1948. So punished even if a state had. So even if a state had committed genocide, he will have to be punished. Then we have European Convention on Human Rights in 1950. So individuals can directly go to international law without state help. In this convention, it was decided. Then we have reparation for injuries suffered in services of UN. ICJ held that UN is also a subject. Then we have Narcotic Drugs Convention 1981. Obligation individuals for crimes. The next concept is place of individuals in international law. What are the place of different individuals in international law? We have first pirates. So pirates are the enemies of international law or any state, and they have to be punished. The next individual is harmful acts of individuals, the one who commits harmful acts, who harm relations of other state. So those who harm other relation of other states have to be punished. The next are foreigners. State gives rights as given to citizens. So for foreigners, the state have to give to rights to them as they give to their own citizens. Then we have war criminals. So Nuremberg and Tokyo Tribunal, it was decided that those who are war criminals should be punished and it should be enforced on them. The next is espionage, the one who sends spies. So sending spies is a crime and it should be punished. The next individual is individuals can claim against own state. So individuals can go against their own state if their rights are violated. Then UN has given certain rights to individuals. The International Covenant on Civil and Political Rights, individual petition against state. So according to this, individual can file a petition against their own state. The next concept is basis or theories or schools of international law. So what are the theories of international law? We have first theory as to law of nature. So what they say is law exists naturally in our surroundings, and we have to see our surroundings to find out the law, international law. The criticism to this is that the different persons give different meanings of international law in this. The next are positivism. The positivists. So what positivist says that international law is created by legislative authorities only. It does not occur naturally. It is created by legislative authorities of state. So criticism. It is applicable if states didn't consent in some cases. Even if states did not give their consent, it was still applicable. So it is the criticism for positivism. The next theory is theory of consent. So this says that international law is a law because only state give consent to follow it. If state does not give consent to follow it, it is not a law. The criticism for this is certain law is applicable without state consent also. The next is auto limitation theory. So what this theory says is that state follow international law because they have restricted themselves. They have restricted themselves. They have put restriction on themselves, the states, and that is why they follow international law. Criticism: state can remove limitation on its own will. Even though state have put limitation on them, they can remove this limitation whenever they want. It is the criticism. The next is a pacta sunt servanda. So what it means is that states will accept and follow agreements in good faith. So if states enter into an agreement, they will have to follow those agreements in good faith. And Article 26 of the Vienna Convention on Law of Treaties 1969 has written this in statute. Criticism: customary rules are not based on agreements. So customary rules are not on agreements, but yet they are still law. Is the criticism for this. The next is theory of fundamental rights. So what this says that man has rights even before states were created. So these are the theories. This concludes first theory.